The Supreme Court heard a petition challenging the Allahabad High Court's decision which declared the UP Madrasa Education Board Act 2004 unconstitutional. Chief Justice D.Y. Chandrachud remarked the Fazil and Kamil programs cannot grant degrees. The bench led by Chief Justice Chandrachud along with Justices J.B. Pardiwala and Manoj Mishra listened to arguments from the appellants. Advocate Manika Guruswamy, representing the appellants, argued that Section 9 of the Act was struck down for mixing religious teachings with regulatory provisions. In response, Chief Justice Chandrachud questioned why the High Court deemed the Act unconstitutional, emphasizing that it simply outlines service terms and conditions. Guruswamy argued that the Madrasa Board offers general education separate from religious instruction. The Chief Justice clarified that the Madrasa Board is not an educational authority but a regulatory body ensuring quality education, stressing the state's role in providing basic education to children. Justice Pardiwala inquired about the value of Madrasa certificates when students apply for postgraduate studies elsewhere. Senior Advocate P.S. Patiwalia referenced a government order from May 2018 which aimed to align the Madrasa Board with CBSE and ICSE standards. Advocate Anas Tanvir, representing the Madrasa Board, noted that the state does not fund Kamil and Fazil courses. Chief Justice Chandrachud responded the state-funded institutions cannot offer religious education. During the hearing, Abhishek Manu Singhvi cited a ruling from the Aruna Roy case referencing Article 28A which allows for limited religious instruction in some cases. The hearing concluded for the day, which the bench likely to continue tomorrow. Arvind Kejriwal faced a setback from the Supreme Court, which declined to provide relief in his case regarding controversial remarks about Prime Minister Narendra Modi's degree. His petition to halt defamation proceedings in an Ahmedabad trial court was rejected. The defamation case was filed by Gujarat University Registrar Piyush Patel against both Kejriwal and Aam Aadmi Party leader Sanjay Singh. Earlier, Sanjay Singh's similar appeal was dismissed by the Supreme Court in April. The petition was rejected by a bench comprising Justices Rishikesh Roy and S.V.N. Bhatti. The Supreme Court has temporarily halted the implementation of the National Commission for Protection of Child Rights (NCPCR) recommendations concerning the admission of children from madrasas to government schools. A bench led by Chief Justice D.Y. Chandrachud, along with Justices J.B. Pardiwala and Manoj Mishra, issued the stay while hearing a petition from the Islamic clerics group Jamaat-e-Ulama-e-Hind challenging the NCPCR's actions. The court has also barred the central and state governments from acting on the NCPCR's recommendations and has issued notices to all states regarding the matter. The NCPCR had recently urged state governments to stop funding madrasas and dissolve the Madrasa Board, suggesting that non-Muslim children studying in madrasas should transfer to other schools under the Right to Education Act. Muslim students were also advised to enroll in government-recognized schools. The central government had directed states and union territories to follow these recommendations. The Supreme Court, while hearing a petition to remove the words socialism and secularism from the Constitution preamble, commented that these terms have evolved in meaning and are now considered part of the Constitution's basic structure. The petition argues that the inclusion of these words in the preamble through the 42nd Amendment exceeds Parliament's powers under Article 368. The bench comprising Justices Sanjeev Khanna and Sanjay Kumar heard the case. Justice Khanna asked Advocate Vishnu Sankar Jain, representing the petitioners, whether he opposed the idea of a secular India. Jain clarified that the petition does not challenge India's secular nature but contests the 42nd Amendment, which added socialism and secularism to the preamble. Justice Khanna remarked that amendments are common and well known, especially the 42nd Amendment, which was enacted in 1976 during Indira Gandhi's tenure. The petition filed by BJP leaders Subramaniam Swamy, Advocate Ashwini Upadhyay, and Balram Singh also questions the appropriateness of altering the preamble without changing the date of its original adoption in 1949. The court has scheduled the next hearing for the week starting November 18. The Allahabad High Court has issued a ruling regarding passport renewal, stating that the process cannot be halted due to pending criminal case. The case involved Syed Ghayasuddin, a resident of Jalaun, whose passport renewal was delayed because of an FIR. His passport has expired on June 26, 2023. Justices Shekhar B. Sharaf and Bipin Chandra Dikshit ordered the passport officer to renew Ghayasuddin's passport. Although the government's advocate opposed the petition, the court referenced the Pawan Kumar Rajbhar vs. Union of India case, confirming that pending criminal cases cannot prevent passport renewal.